The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. This morning we have 3 cases that will be submitted. Those cases are State of Iowa versus Justin Baker, Dylan Clark and others versus Insurance Company, State of Pennsylvania. And the final case is Serena Conradi versus Carrie Rigdon, or Ann Carrie Rigdon versus Vincent Angler Trust. That final case is now submitted to the court without an oral argument, and we'll hear the arguments in the Baker case. Ms. Reinkoester, or excuse me, Ms. Lucey.
May it please the court. We're here today on Mr. Baker's application for further review from the Court of Appeals decision affirming his conviction. There's multiple issues. They're all interrelated and all stem from a traffic stop on April 18th of 2016. Law enforcement stopped Mr. Baker to investigate drug-related activity. Law enforcement lacked reasonable suspicion to make that stop, and if there was reasonable suspicion, the stop, any sort of investigatory results could not be expected from that traffic stop. Terry stops are meant to investigate, and they're intended to momentarily seize a person so law enforcement can determine whether there is criminal activity afoot. It is supposed to be momentary. It is not supposed to be something that would delay the citizen for a long time period. With a traffic stop, you have a much more significant intrusion than you do with an on-the-street encounter.
Ms. Lucey, we look at the whole picture. How do we view the Nevada incident, the evasion incident, and the incident involving the anonymous information?
Yeah.
What do we do with those 3 factors?
The difficulty is that when you look at the totality of the circumstances, you do have to look at each individual circumstance, otherwise you can't evaluate the totality. So the Nevada incident was Mr. Baker had been arrested in the state of Nevada, told law enforcement in Waterloo, and then at that point he was on their radar. He was never charged or convicted of that offense.
Well, that may be true, but isn't it a factor? I mean, this totality of circumstance test, I take it, is pretty broad, and it may be that he wasn't convicted, but it's a penny in the scale, or a feather in the scale, or more than that, or less than that. But isn't it something? And let me drive to the main point I'm getting at, I guess, is that each of these individually might not be sufficient standing alone.
Correct.
I mean, certainly an arrest can't be enough. A history of a drug arrest can't be enough to initiate a stop, because then anybody who had ever been arrested could get stopped and die. So I think that's right. But here we have the arrest worth something. We have this furtive activity around the house, at least. Not too much, but there it is. We have the anonymous tip. Standing alone might be inadequate.
Yes.
But all together, I mean, I'm not sure we analyze each of these in isolation. It's a totality of circumstances all together, and those factors, coupled then with the hand-to-hand exchange, might be enough to get you over the top for reasonable suspicion. So push back.
Yeah, and I would argue that it's not. And it's so difficult to be able to talk about totality without talking about individually. And so, I mean, when you look at individually, you have this supposed evasion of Officer Gersh, I think it was, who was doing surveillance unrelated to him. You know, it's his perception that he tries to avoid him. You know, people don't have to come in contact with law enforcement if they don't want to. And, you know, it's like one little thing. Okay, so he's on my
Wait,
radar.
I mean, if we're talking about the evasion incident, I mean, that's the way you characterized it in your brief, but it strikes me that it wasn't that he didn't want to come into contact with law enforcement, it's that he didn't want law enforcement to see him go into that house, right?
I think that that was the perception. We have no idea what his actual intent is. We have that he did not pull in. You know, there's lots of reasons why he may not have pulled into the driveway. But
And let
again,
me go
that's
back to
fact.
the incident in Nevada. I agree that the arrest doesn't really add anything, the fact that there was an arrest. But you still had, as I understand it, 3 gentlemen from Waterloo driving from California with a distribution quantity of marijuana in their vehicle. And the report came from Nevada law enforcement to Waterloo law enforcement, so that's a reliable tip of people who had firsthand knowledge of that. Why isn't that pretty significant information that can be added to the scale?
What it is it's added, and this is in August. And so he's on their radar, and for the next however many months, 6, 8, 9 months, 6 to 7 months, I think, he's on the radar. But they don't investigate him. They're not watching him. And so there's no indication that he was even, you know, he was never even charged, which means that he was arrested without any sort of proof that that was his drugs or he was involved. But again, I agree with you. That goes into the equation, but it gets very, very little weight. The strongest things that law enforcement have is this alleged anonymous tip, but we have nothing to corroborate that tip. We have the location and the person. Well, if that's enough to say that we're going to go ahead and stop somebody while they're moving on the public street, you know, we might all be in a little bit of trouble.
Doesn't it kind of corroborate the tip that he's living in this house where there's a distribution amount of marijuana? Isn't that kind of corroborated by later the same day he's observed driving into an alley a few blocks away and doing what might well be a hand-to-hand sale of marijuana?
Or it might well be a purchase of marijuana. Or it might well be a, hey, there's my buddy, I'm gonna pull in and say hi.
But I agree, those are all possible explanations, but to say there's no corroboration, I think maybe is a bit of an overstatement, isn't it?
I would say that there is no corroboration to the heart of the allegation. There's corroboration that he is associated with that house, whether he lives there or, you know, he's there frequently because it's his niece's house, and that he is Justin Baker. I mean, that's pretty much the only thing, because we have nothing in the public that would show that he is doing anything. We have something hidden in private that is alleged. It's not like the OWI cases. It's not like White, where there was prediction of future behavior.
You know, once they decide to stop him, he then slows very gradually, which the officers testified is consistent with, you know, texting or alerting people somewhere else. What do we make of that? What weight do we give that?
I think that you don't give any weight to that, because when we're talking about the reason for the stop, it has to be at the time that the stop is initiated. He hadn't slowed yet.
But then do we give that weight to go towards the in support of the warrant application?
If the marijuana is permissible for the warrant application, that probably goes into the factors. But I would submit that the marijuana that is found as he turns the corner and the officer says he you know, ditches it out the window, that is the result of an impermissible stop. I think the other thing is, and it's been a little while since I've seen that video, but my recollection of it is Vinton Street is a fairly busy location. He turns right at the next available street. The only other place he could have turned in to get off of Vinton Street, I think, was a car lot. If that sounds familiar, I think that's what I have in my head. And then he pulls to where he's legally parked. So the slowness, I think you have to take into consideration of, yes, officer, I'm really gonna stop, but I'm gonna stop around the corner. And
Let me ask about this hand-to-hand transaction. I did a Westlaw search, hand-to-hand transaction. It came up with 126, I think, cases, and I started to scroll through them. And it struck me, they fell in a number of categories, the cases, a quick review. Some of them were almost per se a hand-to-hand transaction is reasonable suspicion. Others were not, and others would be hand-to-hand transaction plus. I mean, they required something in addition. For example, some of the cases say, well, if it's in an area known to be a drug market, that's additional circumstance that would support a stop. But navigate me through these cases. What is it about this hand-to-hand transaction that you think takes it outside the scope of the cases that say, you know, that's enough for a stop?
I think the difference, really and truly, is the lack of any other supporting information that this really was a drug transaction. You know, in a lot of the cases, and I think that Roberts is one of the ones that is cited by the Court of Appeals and I think by the AG, Roberts was my case. And so what it was is that they had a controlled buy, and then they had this hand-to-hand transaction, and that prompted them to stop him. So it wasn't just, I didn't see anything, you know, exchanged, but we already had a controlled buy, so we have a pretty good idea of what was happening. Other ones talk about, you know, known activity or known drug activity, a location for that. I'm a little troubled by that analysis because people commit crimes, neighborhoods and locations don't. And so saying that somebody who is in an area where maybe there is drug activity, but not of their own making, we now say you're part of it. So I'm not saying that there is not going to be a situation where there is reasonable suspicion from other surrounding circumstances. A lot of those cases do not involve stop of a vehicle either. You know, it's like, hey, let me talk to you on the street so you can quickly dispel or confirm, and then somebody gets to go on their way. With a traffic stop, what were they intending to confirm or dispel in this situation? What were they going to do? You know, I give them credit that they just didn't, you know, make up a pretext and arrest him and you know, go ahead and search his vehicle and all of that. But what are they expecting to get as a result of the stop? And I think that has to go into the balancing of the intrusion versus the governmental interest. So even assuming that there is reasonable suspicion, and I will not agree that there is, and I understand that there's this, you know, totality, and I'm talking about factors, but when you look at it as a whole, would someone criticize these officers for not making a stop that day, right then and there? No. What is the danger that they are trying to avoid immediately? They didn't have enough to get a warrant based upon the tip, which they already had, the call from Nevada, the evasion, and the tip. So the only thing that really tipped the scales for law enforcement was this alleged hand-to-hand transaction.
That's not true, the only thing. The Nevada thing, I agree that's the starting point. Maybe there was some time between that and the incident at issue. But that certainly is a pretty good, even if you want to call it a hunch at that juncture, but the law enforcement didn't act just on Nevada. They, I think if anything, their radar was up, right?
Sure.
And then they had the hesitation and what they considered avoidance, but yet they still didn't act at that point either. Just tucked it away, I assume. Then they had an anonymous call still didn't act on it immediately, and then seeing a hand-to-hand transaction. Isn't there more than just one incident that we're looking at?
There's things that lead up to, and you know, I totally agree. They had all of that information, which then prompted them to go back and look at him that day. And then they followed him and saw what they saw, you know, for a second as they drove by. One officer says there's two guys by the car. One officer says there's one guy by the car. Didn't see anything exchanged. But what, at that point, should they continue to investigate? I'm not going to say that they should not at that point, but
Well,
does it justify it?
Let's go in reverse. Let's start with the hand-to-hand contact. When two people have hand-to-hand contact, that can oftentimes mean a handshake. So anyone in this courtroom could, if the police observe hand-to-hand contact, could be viewed to be a handshake. But in this instance, it was hand-to-hand contact along with one person then putting their hand in their pocket after the contact. And then you have to wonder, well, is there something more than a handshake? And then can't you then work backwards and say, well, this is the guy that was involved in drugs 7 months ago in Nevada. This is the guy that there's been an anonymous tip. This is the guy that tried to have some evasive actions in his vehicle when we were following him. Doesn't that kind of supply the reasonable suspicion?
I would submit that it does not, and for a couple things. You have testimony as they drove by. You have what he believes is a hand-to-hand transaction because he sees them every day, multiple times a day. We have no information about what pocket this unknown person put his hand in. You know, was he wearing a sweatshirt and put his hand in his, you know, the pocket? Did he put it in his pants pocket? Did he put it in his back pocket? We see, the officer just says, I see two hands together. Well, were they cupped? How was the money exchanged, if there was, you know, how big a bag is this? I mean,
Isn't that exactly suspicious activity? Nobody's saying that the officer knew exactly what happened, but wouldn't you agree that that would qualify as suspicious?
I think it qualifies as, I think that this may have been what I see every day, but what am I going to get by making the stop right now? Or
Well, it's in a
do I
back-
need to
It's in
investigate?
a back alley, and if I understand the facts right, correct me please if I don't, but it's in a back alley, somewhat secluded, and this transaction takes like 30 seconds. I mean, surely we can all agree that hand-to-hand contact isn't a 99% predictor of drug activity. But that's not the question, of course. So it may be that we don't have all the details of how this hand-to-hand transaction happened. Record might not be fully developed, but we do know it's in a somewhat remote area. We do know it happened very quickly. Isn't that enough to make you think that, well, there's a fair likelihood, doesn't have to be a probability, a fair likelihood that this is a drug transaction?
I see I'm way out of time. May I finish?
You may respond.
The record doesn't really show what kind of alley this is. When you look at the video, you kind of see what the location of Richter Street looks like. The description in the motion to suppress is that it's kind of like an alley between two houses, but it's unclear whether it's, you know, what kind of alley. So we also don't know when he pulled in, whether the guy was already there. We don't know if they know each other. We don't know who the person is. I think it's just a leap to say that this is enough to justify this intrusion for this reason.
Could I ask
And
a
I will
quick
stop.
question, Chief? Do you concede that if the stop was valid, the warrant is okay?
I do not.
Why not?
Because what you have, again, is you have the testimony of an arrest without more, evasion without, you know, much, the tip, which is a large quantity in the house. A hand-to-hand, whether he is a buyer or seller, if true, because he's got the baggie. And how do we link that baggie to the house? Because he could have been the buyer.
Thank you.
Thank you.
The bailiff, put the light on top of the podium, please. Ms. Reinkoester, you may proceed.
May it please the court? Reasonable suspicion isn't a mathematical equation in which you can add up each individual circumstance to get to, a sum that magically gets you to reasonable suspicion. So I think the mistake that the defendant makes in this situation is to say, take each individual circumstance and ascribe it a 0, and just say 0 plus 0 plus 0 equals 0. But because reasonable suspicion isn't a mathematical equation that, operates so smoothly, that doesn't really accurately reflect what the standard is. And I think it's probably closer to, baking a cake, which is sort of, if somebody brought you butter, you wouldn't say, well, that's a cake. And if somebody brought you eggs, you wouldn't say, well, that's a cake. And if somebody brought you sugar, you wouldn't say, that's a cake. But you put them all together and, well, maybe you have a cake. And so I think reasonable suspicion operates more closely to that analogy. And
Here's what bothers me about your position. I'm really not so troubled by the reasonable suspicion aspect of it. I'm more troubled by Ms. Lucey's argument that what were they hoping to accomplish by making the stop? In other words, there has to have been some legitimate law enforcement purpose for the stop. What were they investigating with the stop? I mean, were they thinking that they were going to find a bakery inside his vehicle? I mean, to use your analogy, that's an issue she raises, and I don't really read a response to that in your brief.
well, I think the defendant answers his own question in his own brief on page 66 when he says that the reason for the stop was to investigate drug-related activity. And I think that is, shown in the record that is precisely what the investigators wanted to do. And I don't know that anything illustrates that more than the fact that the investigators asked a marked patrol car to pull him over and stop him. They didn't ask to pull him over and arrest him. They clearly wanted to just stop him and ask him questions related to, what was going on, because I think in every step of this investigation, you see that the police officers were collecting information and not acting on only one piece of information. So you have the original arrest in Nevada. They file that away. They have the evasive movements the week before when the investigator was parked out front of his house. They file that away. When they get the anonymous phone call about there being a lot of marijuana at this house and they believe the defendant is selling it, that's when they sort of take the other two pieces and say, I think there might be something going on here. And then they start conducting surveillance on the house. And in doing so, they see the defendant come to the house, stay there for a short period of time, leave the house, and then directly 3 blocks away, he pulls into this alley and conducts what they, in their estimation, is a hand-to-hand drug transaction. And then they say, stop him. So it seems to me that what they're doing is just the next step in the investigation, which is to discover what is going on at the house. Is defendant selling drugs? So I think the investigative purpose is fairly apparent in this case. It's just that the officers never had the opportunity to do it because in the course of the stop, the defendant threw the bag of marijuana out the window, and then of course any need for an investigation in that particular case is obviated because he has sort of changed the landscape of what the investigation would have been. And and I think that changed maybe the whole face of the investigation, because when he was slow rolling to a stop and there was the concern that he was texting someone to alert them that he was being pulled over by the officers, that they then had to move more quickly than they would have, under a more ideal situation. So, the defendant takes issue with them not conducting further investigation, but the face of the investigation changed when the defendant threw this marijuana out the window.
Ms. Reinkoester, let me ask you about this, this hand-to-hand transaction. Now, I know that experienced police officers or a police officer testified that that's kind of the way it's done. But it's also abundantly common in society for people to put their hands together when they come up to each other, as occurred in this case. And so we have this hand-to-hand transaction without anyone being able to identify the presence of any drugs. They don't see any drugs, and without the presence of any money being exchanged. And so, I mean, a drug transaction requires drugs and it requires money. And there's no evidence of that. And so, can we really conclude that this is a drug transaction and not a very common social greeting in our society?
I don't think you can.
Just the transaction.
Sure,
Let's not
sure.
look at the other things. Just the transaction.
I don't think you can conclude that, but I don't think you have to define reasonable suspicion, because an officer isn't required to, eliminate any possible innocent activity before acting on what they believe might be, a crime that's being committed. That's sort of the nature of suspicious activity, is that it's susceptible to two or more, meanings, one of which could be something that was perfectly innocent, which is that he saw his friend in an alley and stopped to say, hey, in a sort of odd way.
But this is such a common transaction that aren't we sweeping in the risk sweeping in people that are engaging in what would be another logical explanation that's so common in society?
I would agree with that if that was the only reason by which they, conducted the stop, but that's not. And I think that, Ms. Lucey is right in the sense that you can't look at the totality of the circumstances without looking at the individual pieces of it, but you also can't look at the individual pieces so strongly that you lose the forest for the trees. And so, I agree that if they had only seen this, it would have been highly suspicious. And, I agree, especially under the circumstances of this case, which is that he, if we're just talking, trying to look at this in isolation, which I, push back at. But if you're looking at
the coup
it.
d'etat is the transaction. The police are witnessing the transaction, and yet they make their case based upon all this tangential stuff in the past. They don't see any drugs exchanged. They don't see any money exchanged, but they see a handshake. Why can you see, what is it about the handshake without the transaction including any drugs or money?
Well, I don't think we can discount the testimony of the officers who witnessed this hand-to-hand drug transaction. I mean, these are two officers who work exclusively with the Tri-County Drug Task Force, who have spent years only investigating drug-related activity, who, when they drove by, saw what in their estimation was a hand-to-hand drug transaction. And I don't think we can discount that experience, and especially under the reasonable suspicion standard, we are supposed to give credit to the officers' experiences when they are determining whether something looks like suspicious activity.
But there still has to be factors to back up their observations, and the only factor that we have is what would appear two hands coming together. That's it.
But that isn't the only factor we have, because we have all of the circumstances that happened before that. And I really don't think you can look at just the hand-to-hand drug transaction in isolation from those other things, because clearly those other circumstances, weigh into the determination of whether or not they believe that some sort of criminal activity is happening.
And that's what the big struggle here is. But should we require something a little bit more than just the observation of a handshake? Should we require, regardless of the other circumstances, should we also require that there at least be some observation of some cash or some observation of some drugs or an object. There isn't anything here as to the actual transaction to conclude that it was anything but a handshake.
Well, I don't think that's
If you
true.
focus on the hand-to-hand.
But I don't think that's true, because selling drugs and buying drugs isn't like going into a grocery store and buying something off the shelf where it's very obvious that someone's gonna, take a milk and walk it up to the grocery store. You have someone who drives into an alley for 30 seconds, and he has two people approach the passenger side of his car. They lean, this testimony is all in the motion to suppress hearing, so you can see it there. But they lean in like this, pull out, and put their hand right into their pocket. Now, we're talking, a small bag of marijuana and, maybe a $20 bill. It's very possible that you're never going to see that, with a hand-to-hand drug transaction, because the whole point is that you don't see it, because you're trying to do it as quickly and as secretively as possible so that you don't get in trouble. And so I don't think you can ascribe just the fact that they didn't see drugs or cash change hands as enough to undermine the idea that this was a hand-to-hand drug transaction.
And doesn't the location increase the level of suspicion? If it's a friendly hello and a handshake, wouldn't it be kind of odd to meet in a secluded alley and then have that contact so fleeting and the old friend walks away?
I would agree, especially under the circumstances of this case where it's such a short transaction, so it's not, likely that, it's more likely that they were there waiting for him after arranging for them to meet him than they were just standing there and ran into a friend. I do want to spend a little bit of my argument just addressing defendant's ineffective assistance of counsel claim. He actually appealed 3 different district court cases in this appeal, only 2 of which are really at issue. But they all, well, the third one doesn't, but there are 2 cases which arise from the exact same set of facts that we've been discussing this morning. And one, they charged him with a felony with possession with intent to distribute. And then a second, they charged him with driving while barred, and then just simple possession of the marijuana that he tossed out the window. And in his brief, defendant argues that his trial counsel was ineffective for failing to file a motion to suppress in that case, because it should have been granted for the same reasons as he's been arguing. And then if it had been granted, he would never have pled guilty, which is what he did in that case. And I just want to direct the court's attention to the confidential appendix on page 17, which is the record for the aggravated misdemeanor. And in that, the sergeant who pulled over the defendant states, "I stopped the vehicle at the request of the Tri-County Task Force investigator as it pertained to an ongoing investigation. The driver was also known by investigators to be operating a vehicle without a valid license." So it appears that in the record for the aggravated case, at the very least, it somehow did not make it into the felony case, but in the aggravated case, that the officers had probable cause to stop defendant's vehicle because they knew he was driving while barred. So at the very least, in his ineffective assistance of counsel claim, we would say that they weren't ineffective because the counsel could see from the record that there was probable cause to stop defendant's vehicle and would know that their motion to suppress would be futile. And also,
I have another question. Back to, they enter the house initially without a warrant, and did that, what they saw there and included in the warrant application, even if you disregard that, did that taint the warrant?
I don't think so, because the warrant application was 5 pages long, and the only, I think it's, three paragraphs of the 5-page application is what the observations were of the officers when they entered the house. And so striking that information, at least the district court agreed that there was still sufficient evidence for probable cause without that information in the warrant. And also, just to say in terms of remedy, if the court is inclined to say that there isn't reasonable suspicion for the stop, because there does appear in the record that there was an alternate reason for the stop, which is that the officers knew that the defendant was driving while barred, we would ask the court to reverse and allow the state to present additional evidence on why defendant's stop was valid. Thank you very much.
Counsel, thank you as well. Ms. Lucey may present your rebuttal.
I'll begin where
Yeah, that was my
Go ahead.
question. Could you address the argument we just heard about the alternative ground to support the stop?
what we have is sworn testimony from Sergeant Bowes, why he made the stop. He stopped at the request of Isley and Gersh to investigate drugs. He never said, I knew he was barred. The police report, as the state just pointed out, says knew he was driving without a license. There is no evidence that he confirmed that he was barred prior to the stop, that was the reason for the stop, and the state should not get another opportunity to try to prove that this was or was not a good stop, because then we're going to go into the whole pretext thing on remand. Anyway, I disagree with the state's demonstration of what the handshake looked like, because there's nothing in the record to support what that handshake or hand-to-hand contact looked like.
Well, no, I also think is not quite correct, Ms. Lucey. I mean, here's the testimony. I'm reading it. I saw a man stick his, I believe it would have been his right hand, into the passenger window and immediately pull it back out and stick it into his right pocket. Now, that could be a handshake. I mean, I think the testimony is that, but that's not maybe the way a handshake is normally done. Normally, you're not going like that.
It could also be that kind, where you have the slap, very little contact, and be done. You know, I think that trying to decide what a normal handshake looks like on any given day, we have different people and different ways of greeting.
And then you have the added circumstance that the defendant drives the car down the alley in order to have this encounter. It lasts 30 seconds, immediately leaves. I mean, again, you're right, it all could have been a social encounter, but is there reasonable suspicion in the view of these trained officers that it was something other than that? Isn't that really the issue?
And I think where we keep running into this idea of these trained officers see what they think they see. And I'm not saying that that is necessarily a wrong or bad thing.
And actually, they saw probably what they thought they saw is probably what happened, right?
I don't think we know that. You know, we know that Mr. Baker had a baggie of pot at the time that he was stopped. You know, that's what we do know.
Are you asking for us to consider, when there is a drug transaction, that it would be more reasonable to have somebody, here's the marijuana, here openly, and the other person take out their wallet and hand them some money? Do you really think it'd be that obvious?
In a normal situation, probably not. There probably are some transactions that are that open in the streets. But I'm not saying that it needs to be that. But it has to be something that we know that there is an exchange versus we think that there's an exchange. And when we look at
But do you agree they are trying to do something secretive if there is a drug exchange?
in this case or always,
In general, in reasonable case, I'm just, as far as suspicion, do you think typically that behavior is they attempt to keep it secret?
you would think so, but quite honestly, I'm not sure that that's always the case. You know, I think that there is situations where there is very clear and open drug market on some streets and in some houses. I mean, I think there is. What we have here is he goes in an alley, and I really wish that we had a better idea of what that alley looked like. And the officers say 30 seconds. But that's them driving by and then him going. So, I mean, we don't know. We only know what the record says. But I would leave you with this. What is the purpose of this stop? The purpose is to investigate drug activity. So when you balance the intrusion based upon the governmental interest, you know, do you have need for swift action? Is this traffic stop really just a forced knock and talk? He can't leave. Could they knock on his front door and say, hey, we want to talk to you about drug activity? Yes. Then he can choose not to. So is it a forced knock and talk? He doesn't have an option of walking away. So based upon that balancing for an investigative stop, it can't be permissible even if they're reasonable suspicion.
Let me understand, because I think I'm out of time. Thank you.
Thank you.
Ms. Lucey, thank you. Ms. Reinkoester, thank you again. The case of State versus Baker is now then submitted, and we'll now hear the arguments in Clark.